Every week, I speak with numerous individuals who want to consider making an investment in the United States and apply for an E-2 visa. An E-2 non-immigrant visa may be issued to a citizen of a treaty country to oversee their investment in the United States or work with a U.S. business, which is at least 50% owned by citizens of the treaty country. Here are 5 important things to know about the E-2 category for startup companies. First, know that there is no minimum dollar amount for a qualifying investment that is set out in the regulations. Rather, the government's looking at your startup business in the United States and determining whether the initial funds are substantial in a proportional sense for the type of business that's beginning. The government wants to see a sufficient investment that will ensure the treaty investor's financial commitment to the successful operation of the enterprise. Second, know that the government really cares about that money trail. E-2 applications require you to carefully document the origin of investment funds to prove they're from a lawful source, and to also show how those funds were ultimately made into the U.S. enterprise. The investor must show that they are at risk in the commercial sense and liable for the business if it flops. This concept can get complex, and that is where I think it's most important to have professional guidance to ensure your investment is properly structured for E-2 purposes. The third important E-2 fact is that your startup business must be a real operating enterprise. It's not enough to transfer money into a U.S. business banking account. At the time of the application, the startup must actually be operating or able to immediately begin business at the time the first applicant applies for an E-2 visa. This usually means a lease or sufficient physical premises are secured, inventory or office equipment has been obtained, a business plan has been created, and licensure and other business necessities are in place. For the fourth fact, this might be a bit of a surprising one. We know that an E-2 investor may be the actual owner who's coming to the U.S. to direct the startup business. But did you know that an employee of the business who will work in an executive, managerial, supervisory, or other essential capacity can also obtain an E-2 visa? These individuals can qualify for the E-2 even if that principal owner isn't working in the United States. The key is that such employees must have the same nationality as the principal owner investor. And finally, number 5. Spouses and children under 21 are able to apply for E-2 dependent visas at their local embassy or consulate. Once in the United States, spouses of E-visa holders may apply for work authorization with U.S. Citizenship and Immigration Services upon submitting the appropriate paper application and applicable filing fee. Children of E-visa holders can't apply for work authorization unless they qualify for a different category in their own right, but they may attend school in the States. And that's the E-2 in a nutshell. As you can see, E-2 applications for startup companies should be strategically prepared. There are a lot of important factors to consider. It's important to have the right immigration lawyer on your team during this important time for your startup business. I encourage you to give Berardi Immigration Law a call. We know what it takes to prepare a successful E-2 visa application, and we look forward to hearing from you.